I call this meeting to order. Welcome to meeting number 18 of the House of Commons Standing Committee on Access to Information, Privacy and Ethics. Pursuant to Order 1083H and the motion adopted by the committee on Monday, December 13th, 2021, the committee is resuming its study of use and impact of facial recognition technology. Today's meeting is taking place in a hybrid format pursuant to the House Order of November 25th, 2021. The members are attending both in person in the room and remotely using the Zoom application. Per the Directive of the Board of Internal Economy on March 10th, 2022, those attending the meeting in person must wear a mask, except for members at their place during proceedings. I would like to make a few comments for the benefit of witnesses and members. First, to wait until I recognize you by name before speaking. And those participating by video conference, click on the microphone icon to activate your mic, and please mute yourself when you are not speaking. Interpretation for those on Zoom, just so that you're aware, you have the choice at the bottom of your screen of either having just the floor audio or to select English or French. For those in the room, you would use your earpiece and select the desired channel as you normally would. So now I would like to welcome our witnesses from the Office of the Privacy Commissioner of Canada, Daniel Therrien, Privacy Commissioner of Canada, and Daniel Weinkoff, Senior Information Technology Research Analyst. From the Office of the Information and Privacy Commissioner of Ontario, Patricia Kosim, Commissioner, and Vance Lockton, Senior Technology and Policy Advisor. From the Commission d'Accès à l'Information du Québec, Diane Poitras, Président. And so now we'll go to our first witness. For each witness may deliver an opening statement of up to 5 minutes. Go ahead, Commissioner Therrien, you have the floor.
Merci beaucoup.
Thank you very much. Thank you, Mr. Chair. Thank you for inviting me here today, and thank you for undertaking this important work on facial recognition. Like all technologies, FRT can, if used responsibly, offer significant benefits to society. However, it can also be extremely intrusive, enable widespread surveillance, provide biased results, and erode human rights, including the right to participate freely without surveillance in democratic life. It is different from other technologies in that it relies on biometrics, permanent characteristics that, contrary to a password, cannot be changed. It greatly reduces personal autonomy, including the control individuals should have over their personal information. Its uses encompasses the public and the private sectors, sometimes for compelling purposes like the investigation of serious crimes or proving one's identity, and sometimes for convenience. The scope of your study is vast. In the time I have available, I will focus on the use of FRT in a law enforcement context. When we last spoke on your current study, my office had completed its investigation into Clearview AI, a private sector platform that we and our colleagues in Quebec, BC, and Alberta found was involved in mass surveillance. Since then, my office examined the RCMP's use of Clearview's technology. We found that the RCMP failed to properly assess the privacy risks involved and that it lacked a system for ensuring that new technologies respect our legislation. Ultimately, we determined the RCMP's use of Clearview to be unlawful since it relied on the illegal collection of use of facial images by its business partner.
Findings, we worked with fellow privacy commissioners across Canada to develop joint guidance for police use of facial recognition, meant to assist police in ensuring any use of the technology complies with the law, minimizes risks, and respects privacy rights. We are releasing the final version of the guidance today. As part of this work, we launched a national public consultation on police use of facial recognition technology. During this consultation, we heard consistently that the current laws regulating the use of facial recognition did not offer sufficient protection against the risks associated with the technology. While all stakeholders we consulted agreed the law must be clarified, there was no consensus on the content of a new law. Legislators will therefore have to decide how to reconcile various interests. Following this consultation, fellow provincial and territorial privacy commissioners and I believe the preferred approach should be to adopt a legislative framework based on 4 key elements, which we have outlined in a joint statement we're issuing today. First, we recommend that the law clearly and explicitly define the purposes for which police would be authorized to use facial recognition technology and prohibit other uses. Authorized purposes should be compelling and proportionate to the very high risks of the technology. Second, since it is not realistic for the law to anticipate all circumstances, it is important, in addition to limitations on authorized purposes, that the law also require police use of facial recognition to be both necessary and proportionate for any given deployment of the technology. Third, we recommend that police use of facial recognition should be subject to strong independent oversight. Oversight should include proactive engagement measures, such as PIAs, program-level authorization or advanced notification before use, and powers to audit and make orders. Finally, we recommend that appropriate privacy protections be put in place to mitigate risks to individuals, including measures addressing accuracy, retention, and transparency in facial recognition initiatives. I encourage you to consider our recommendations as you complete your study of this important issue. Je vous remercie de m'avoir donné le...
Thank you for the opportunity to appear before you today. I look forward to your questions after my colleagues. Thank you.
Thank you. And now for up to 5 minutes, Commissioner Cosine.
Bonjour et merci de m'avoir invité.
Good morning, and thank you for inviting me to speak today. I have with me Vance Lockton, Senior Policy and Technology Analyst with my office. I would like to build on the remarks you've just heard from Commissioner Terrien. While Canada's privacy commissioners recommend the adoption of a comprehensive framework to address the use of facial recognition technology in the criminal law context, we also recognize that some police agencies are already using or considering using facial recognition technologies. As such, we have issued guidelines to help guide law enforcement agencies in the interim and mitigate against potential harms until a new statutory framework is put in place. I would like to emphasize 5 key elements of the guidelines. First, before using facial recognition for any purpose, police agencies must establish that they are lawfully authorized to do so. This is not a given and cannot be assumed. Facial recognition relies on the use of sensitive biometric information. Police should seek legal advice to confirm they have lawful authority either at common law or under statute specific to their jurisdiction. They must also ensure that they are charter compliant and their purported use is necessary and proportionate in the circumstances of a given case.
Agencies must establish strong accountability measures. This includes designing for privacy at every stage of a facial recognition initiative and conducting a privacy impact assessment, or PIA, to assess and mitigate risks in advance of implementation. It also involves putting in place a robust privacy management program with documented policies and procedures for limiting purposes, robust systems for logging all related uses and disclosures, and clearly designated roles and responsibilities for monitoring and overseeing compliance. Such a program must be annually reviewed for its continued effectiveness. It must be supported by appropriate training and education, and ensure that any third-party service providers also comply with all related privacy obligations. Third, police agencies must ensure the quality and accuracy of personal information used as part of a facial recognition system to avoid false positives, reduce potential bias, and prevent harms to individuals and groups. Ensuring accuracy involves conducting internal and external testing of the FR system for any potentially discriminatory impacts, as well as building in human review to mitigate risks associated with automated decisions that may have significant impact on individuals. Fourth, police agencies should not retain personal information for longer than necessary. This means destroying probe images that don't register a match and removing face prints from the database as soon as they no longer meet proper criteria for inclusion. Fifth, police agencies must address transparency and public engagement. Direct notice about the use of facial recognition may not always be possible in the context of a specific police investigation. However, transparency at the program level, such as publishing the agency's formal policies on the use of facial recognition, a plain language explanation of their program, and a summary of their PIA, certainly is possible. Any communication with the public should be two-way. Key stakeholders, particularly representatives of over-policed groups, should be consulted in the very design of a facial recognition program. Given the special importance of reconciliation in Canada, this must include input from local Indigenous groups and communities. So these are a few of the measures set out in the guidance. To reiterate, although we believe these guidelines represent important risk mitigation measures, ultimately, we recommend the establishment of a comprehensive statutory regime governing the use of facial recognition by police in Canada. Clear guardrails with force of law are necessary to ensure police agencies can confidently make appropriate use of this technology, grounded in a transparent framework, accountable to the people they serve, and capable of earning the public's enduring trust. Thank you.
Merci. Et maintenant,
Thank you. And now for Ms. Poitras from the Access to Information Commission of Quebec. You have 5 minutes. Thank you, Mr. Chair. First, thank you for the invitation to discuss facial recognition. In addition to what my colleagues have said, I would like to briefly address the issues raised by other uses of this technology and to present what the Quebec legislation provides. As mentioned by several stakeholders, the increasing use of facial recognition in a variety of contexts raises important issues, including privacy issues. This technology, which combines biometrics and artificial intelligence, is particularly invasive, especially because it collects and uses unique characteristics of the body and turns them into data. These characteristics, such as certain facial features, are central to our identity. The fact that this technology can be used without our knowledge increases the loss of control over our information and the risks of undue surveillance. Some proposed uses for facial recognition infer intimate characteristics from our face or facial expressions such as age, gender, ethnicity, emotions, attention span, fatigue or stress levels, health information, or certain personality traits. These characteristics can be used to categorize, detect, or profile individuals for commercial purposes, to conduct some form of surveillance, or to make decisions about them. The creation of biometric information banks also poses significant privacy risks. It is difficult for an individual whose biometric data has been compromised to challenge a transaction or action in the event of error or identity fraud, given the high reliability placed on this unique and permanent information. since it is nearly impossible to replace a compromised biometric. Restoring one's identity can be just as complex. Let us also underline that the high risk that these biometric banks created for a specific purpose will be used for other purposes without our knowledge and without an adequate assessment of the issues and risks of this new use. This is why the creation of such banks and the use of biometrics for identification purposes are regulated in Quebec by the Act to establish a legal framework for information technology and by the laws protecting personal information applicable to public and private organizations. Thus, the creation of any biometric bank must be declared to the Commission. As of next September, the same will apply to any use of biometrics for identification purposes. In Quebec, biometrics cannot be used for identification purposes without the express consent of the person concerned, and no biometric characteristics can be captured without his or her knowledge. Only the minimum number of biometric characteristics may be collected and used. Any other information that may be discovered from these characteristics cannot be used or retained. Finally, the biometric information and any notes relating to it must be destroyed when the purpose for which the identity was verified or confirmed is fulfilled. The Commission has broad powers and may make any order regarding such banks, including the power to suspend or prohibit the operation or order its destruction. In addition to these specific provisions, the general rules on the protection of personal information apply. This implies that, among other things, that the use of facial recognition must be necessary and proportionate to the purpose. We find that organizations are not giving as much importance as they should to this compliance assessment and to the challenges of using facial recognition. The popularity of biometrics has led to a certain trivialization of its implications for Canadians. This is why the Commission recommends that a privacy impact assessment be conducted beforehand. Such an assessment will be mandatory as of September 2023. Furthermore, biometric information will be specifically designated as sensitive personal information. Although the current framework for biometrics in Quebec allows the Commission to have a certain picture of the use of facial recognition and grants it powers of intervention, we have asked that it be improved to take into account the evolution of this technology and the different contexts of its use. Thank you for your attention, and I look forward to speaking with you in the next few minutes.
All right, and with that, we'll go straight to questions, and Mr. Kirk for up to 6 minutes.
Thank you very much, and I appreciate all of the commissioners today and your expertise. Just to all the witnesses, I'm hoping that we'd be able to get a copy of that joint statement to enter into testimony, just to confirm that can be perfect. Thank you very much. Thank you, Commissioner Therrien. It's certainly over the last number of meetings where we've had. Where we've jumped into this study, we've learned a lot and heard a lot about some of the challenges associated with facial recognition technology. So I'd like to ask, you've referenced the consultations that were done, and I'm curious if you could outline for the committee what that consultation looked like in terms of facial recognition technology and its use, some of the stakeholders that were involved in that consultation, and some of the trends that you may have noticed during that process.
Our investigative report about the RCMP's use of Clearview last June in a special report to Parliament. We started at the same time a consultation of stakeholders who were interested to speak to draft guidance that we had published at the same time. That led to about 30 groups or individuals writing to us. And we also had a number of meetings with a number of stakeholders. So the stakeholders represented civil society, minority groups, the police itself. I met a number of times with the RCMP and with the Canadian Chiefs of Police Association, and my colleagues also met with provincial equivalents. So there was a broad range of people who were consulted. Views were varied, obviously, because the interests were different, but all agreed that the law is insufficient as it is, and depending on interests of various stakeholders, they did not agree necessarily on the content of that law.
Sure. In your opening statement, you had said that there was no clear consensus found by stakeholders. And certainly that's the sentiment that I've certainly found as we've heard from different witnesses. So I'm curious if you could and we did hear the RCMP very very clearly say that they had disagreed with your office's findings in terms of their use of Clearview AI. So I'm curious if you could share with the committee some of your observations about the trends that you found when consulting with the wide variety of groups that you've engaged in this process.
I would start first with where there was agreement beyond the law needs to be changed. Many people felt that the guidance was drafted or crafted at a level of generality such that the advice is helpful, but they would like it, at the very least, to be supplemented by advice on what was called use cases. So our reaction to that is, indeed, there is a need for advice on particular uses in different contexts, because context matters a whole lot. But we still think it's important and relevant to have general guidance to be augmented as use cases are developed. Some stakeholders from civil society or minority groups called for, say, a moratorium on the use of facial recognition. The RCMP obviously did not agree with that. Our position as commissioners is that there should be clear not guidelines, but law ultimately, prescribing when facial recognition can be used, because it can be used for legitimate, helpful purposes, social good in some circumstances. For instance, in serious crime situations, or to find missing children. But these uses should be defined quite narrowly, and the law should also prescribe prohibited uses, which would be, I guess, a partial ban or a partial moratorium on the use of facial recognition. If I may, on the question of a moratorium, so we as data protection authorities cannot impose a moratorium that has the force of law. For a moratorium to be binding on police agencies, it would have to take the form of legislation. But I was struck by the testimony that you heard last week from an RCMP representative to the effect that the RCMP, I'm quoting, believes that the use of facial recognition must be targeted, time-limited, and subject to verification by trained experts.
If I could, and I apologize, there's a lot of subject here. If I could just ask one question, maybe because of time limitations, would you be able to provide the committee with maybe a list of best practices, other jurisdictions from around the world that have already provided some of these frameworks for the committee to be able to reference and point to as well?
Sure.
So I apologize, but I think I'm basically out of time. So thank you very much to all the witnesses for coming today and your expertise. Thank you.
And now, Mr. Fergus for 6 minutes.
Merci beaucoup, Monsieur le Président.
Thank you very much, Mr. Chair. I would like to thank our witnesses, Ms. Batra, Mr. Terrien, and Ms. Kosheim. I will start with you, Mr. Terrien, and then I will ask questions of the two other commissioners. I know that you created a report on the use of facial recognition for the RCMP, and thank you very much. I found it very useful and very interesting. But I would like to take a step back and apply it to everyone, not only to government, but to the private sector as well, like the government of Quebec is trying to do. I would like to know what your perspective is. The comments that you gave to the RCMP, could that be used with the private sector with regards to the use of facial recognition? Answer: whether it be law enforcement or other departments, governments, and companies? Yes. My colleagues talked about the importance of proportionality, and I believe that that can apply to all stakeholders who want to use facial recognition. In policing, using facial recognition can have very significant impact. It can mean a lack of freedom. There are a lot of common elements. There are a lot of principles that should be common, and everyone, including legislators, should take into account the context and what the impact of facial recognition is. And a complete ban in certain circumstances is something that we could recommend for law enforcement, might not apply to other actors as well. I agree with you. For law enforcement, this has a significant impact. We had a few witnesses that came from the United States, from Princeton University, who stated that governments have a role to play, but so do private companies. For example, if somebody uses this technology to find out how you're feeling or to see if you're a bad credit risk, this could cause significant and serious impacts to Canadians. And there's not enough data on its use either. Ms. Kosin, thank you for identifying 5 elements. Do you believe that these 5 elements can also be applied to the private sector? Thank you for the question. As my colleague mentioned, these principles should apply regardless of the sector and take into account the context, of course, and the wide variety of risks. In Ontario, I would like to specify that we don't have any privacy legislation for the private sector. So we have proposed to the government that they adopt such legislation. In most cases, companies are subjected to the federal legislation, but that means that there are a lot of shortcomings in Ontario. For example, employees of most companies are not protected by any legislation. Nothing protects their privacy, and that is an important gap. And these basic principles that we highlight in our guidelines are important. And of course, it can be adapted to other contexts. So we have the guidelines, and they were created for law enforcement. Thank you. I don't mean to interrupt you, but I know I only have about a minute left. Ms. Poitras, I would like to congratulate your bill that would force companies in 2023 to comply with the legislation, and they will have to be registered. And can more be done in Quebec and at the federal level as well to protect individuals from the impacts of facial recognition technology? federal facial recognition technology? Should we adopt a federal legislation that would be similar to what exists in Quebec? Thank you for your question. To respond very briefly, Mr. Chair, the legislation that we have in Quebec is just a start, but we have certain recommendations to improve it. For example, there are obligations for the use of biometrics, including facial recognition for identification or identity verification. And through the declarations that we are receiving from biometric information banks, there are other uses that are being done, and I talked about it during my presentation. So that would be a first recommendation. I apologize. Inaudible. Microphone, please. Can we ask the witnesses to share anything else in writing to the committee? Yes, perfect. Thank you.
You did not, Mr. Fergus, permit very much time for this witness to answer that question. So I'm sorry, we will have to move on. And maintenant, Monsieur Villemeux pour.
Mr. Villemeux, you have 6 minutes. Thank you, Mr. Chair. I would like to thank the commissioners for being with us today, and I would like to congratulate you for publishing that framework, which is something that we were very excited to see. Mr. Terrien, can you say in a few words how you would define surveillance? It can take different shapes. When it's used by private companies or law enforcement, it's the collection of information on activities or characteristics of individuals in a way to make a decision on these individuals. And the question to be asked is whether or not they have the consent to do so, or if they are complying with legislation to protect people's privacy. That is key here. Consumers with companies and Canadians with the government should be able to exercise their rights to use social media or to communicate or to protest without being subject to mass surveillance, and only for very limited reasons. Thank you very much. So for police officers that are filming protesters, we heard that there are no archives, but that is a form of surveillance, correct? Yes. So you were talking about the RCMP earlier, about our witnesses from last week. Can you tell us more about what you were saying? So there was a question asked regarding whether or not a moratorium should be implemented until legislation is adopted. I believe that a moratorium should look like legislation so that it can be binding. But I heard from the RCMP last week that they spoke about the use of the RCMP.
Subject to verification by trained experts. Further, it should not be used to confirm an identity, but rather to be only as an investigational aid. Et la question de la revue par...
And the matter of it being reviewed by a person was raised. The easiest way to reach a moratorium until improvements are made to the legislation, well, you could ask the RCMP to commit to only using facial recognition in the context raised by its representative. And those were reasonable reasons, correct? Yes. Ms. Poitras, could you summarize the Clearview situation, which was very significant in Quebec? Thank you very much for the question, Mr. Chair. As you know, the Commission worked with its counterparts, federal counterparts, and from Alberta and BC. And we then created an order through our powers, and it was appealed in Quebec, and so it is currently before the court. So I don't mind sending you the decision that will be rendered that explains our position and is available on our website. But unfortunately, because the matter is before the courts, I currently cannot give any comments. Thank you for sending us the document. And if it's not going into anything secret, what is Clearview appealing? To summarize the decision, it started with the Commission's jurisdiction because it is an American company, as well as our decisions on the compliance with our Quebec legislation. Mr. Terrien, do you believe that the RCMP is already conducting surveillance? From what I heard last week, the RCMP says that they're not doing any mass surveillance, and I don't have any reason to doubt that statement. A way for the RCMP to show that they use facial recognition for good reasons would be to commit to only using that technology for those reasons. I noticed last week that the RCMP's representative was not very clear with regards to whether or not the RCMP uses facial recognition. So I don't have any reason to believe that they're using facial recognition for mass surveillance, but the definition of the circumstances of the use of facial recognition seems a little murky and ambiguous, and that's why we are sending out the document today, and that is why we believe that law enforcement should have to comply with specific legislation that would prohibit the use of facial recognition in certain circumstances. Thank you.
Mieux. Et maintenant, welcome to the Ethics Committee. Ms. Gazan, you have up to 6 minutes.
Thank you so much, Chair. Monsieur Therian, so your office.
Point of order, Mr. Chair.
Pas de traduction non plus. Il n'y a pas de traduction.
There was no interpretation. The microphone wasn't on. Microphones, please.
I have mine on English.
Okay, right.
Yeah.
Your microphone was not activated.
Oh, it was not. Sorry. Okay, sorry about that.
So go ahead, Ms. Kazan, and I'll ask
Okay.
you to restate your question.
Thank you. This isn't my first committee, just so you know. Sorry, everybody. Thank you, Chair. Monsieur Therian, the Office of the Privacy Commissioners published a report in June 2021 titled Police Use of Facial Recognition Technology in Canada and the Way Forward. And this report provides a series of recommendations that the RCMP agreed to implement no later than 12 months after receipt of that particular report. And some of the recommendations included a training program to ensure decision makers are trained on the limitations on collection of personal information under the Privacy Act, policies to clarify who can make decisions on the collection of personal information, and systems to monitor for unauthorized collections. Could you elaborate on the recommendations you made that the RCMP agreed to and how these will improve privacy practices?
Thank you for that. So while the RCMP disagreed with our conclusion at law that itself, the RCMP was breaching the public sector law by relying on Clearview, they did cooperate significantly with us in one, recognizing that they should have a better verification system when they use new technologies, be it facial recognition or other new technologies. So we have, I think, agreement with the RCMP that they ought to have these verification systems, and we have had good discussions with them since June of last year. I do not think that they will be able to implement all of these recommendations within a year, but we're making good progress.
But they had agreed to implement them no later than 12 months after receipt of the report. So what you're saying is that they have not implemented the recommendations, and it's been over 12 months. Am I correct?
They have not yet, and they are unlikely to meet the 12-month deadline, but we are making good progress, and I see a genuine effort on their part. It is a relatively complex issue, but we obviously would like to see this implemented as soon as possible.
Okay, moving on. So in June 2021, the OPC report also stated that, in quotes, there were serious and systemic failings by the RCMP to ensure compliance with the Act before it collected information from Clearview and, more broadly, before novel collection of personal information in general. This includes widespread failures to know what it was collecting, control how collection occurs, identify potential compliance issues, and assess and prevent contraventions of the Act. The use of the words systemic and widespread suggests that this isn't a one-off error or poor decision. So, systemic and widespread. So how can we be assured that the RCMP is compliant with privacy laws going forward and that there aren't other cases like Clearview quietly flying under the radar? I think I ask that because it uses the words systemic and widespread.
This language refers back to the absence at the time at the RCMP of any system to ensure that when new technologies are used by its officers, that there's a verification and approval process within the RCMP to ensure that that technology respects the law, including privacy rights. This was far from ideal, to say the least, but the RCMP has recognized the problem, is setting up such a system. It will take a bit more time than we had hoped, but I think it's going in the right direction.
So I find that concerning because we're dealing with privacy issues. When you say it'll take a bit more time, could you give us an approximate amount of time? I think I asked that because initially they said that the recommendations they were supposed to put in place 12 months after they report. They have not done that. We know that it's systemic and widespread. So what is the duration of time you think it'll take for?
The RCMP has set up a system. It's the implementation of the details of the systems. For instance, the training to be given to officers, that is taking more time to define than we had hoped. I would suggest that you ask the RCMP how long it's going to take. We have asked them ourselves, obviously. I can report on what the RCMP has told us. I can undertake to do that. So I will do that.
Thank you so much. Would you be able to submit that to the committee? Is it possible?
Yes.
Okay, yes. Thank you so much. I'm not sure how much time I have, Chair? Sure. How much time I have, Chair? 20 seconds?
You've got time for a very quick question.
Oh, okay.
Sorry,
Yeah. I have time for,
you've
okay.
got very quick, though.
In a joint investigation of Clearview, I don't know how much time I have now? None. Okay. Okay, great. Very good. Thank you.
You've got time today, and I'm being a little generous, so go ahead with a question, and a brief question, and we'll a brief answer, and then we'll move on.
Thank you so much, Chair. So in the joint investigation of Clearview by the Privacy Commissioner of Canada, the Information and Privacy Commissioner for British Columbia and the Information and the Privacy Commissioner of Alberta, the offices recommended that, one, cease offering the facial recognition services that have been subject of this investigation to clients in Canada. Two, cease the collection, use, and disclosure of images and biometric facial arrays collected from individuals in Canada. And three, delete images and biometric facial arrays collected from individuals in Canada in its possession. Has Clearview taken any of these actions?
Clearview has stopped offering its services in Canada, I believe in 2020, while we were still investigating. But it is in court challenging the decisions of my colleagues, I believe, because they do not want to give an undertaking in perpetuity that they will not offer their services. But at this point, they are not offering their services in Canada.
Thank you.
Now, for 5 minutes, Mr. Williams.
Thank you, and through you, Mr. Chair, to Mr. Therian as well. As you mentioned last week, we had the RCMP and in response to the findings that the RCMP's use of Clearview AI was illegal, they say they disagreed with your findings. A representative reiterated that stance. Does the reason for disagreeing with your findings have any merit? Why or why not?
I'll give a lawyerly answer, which I think will be clear. The provision at play is the provision of the Privacy Act that governs the collection of information here by the RCMP. What the RCMP is saying is that section 4 of the Privacy Act, does not explicitly require a federal institution such as the RCMP to ensure the legality of the practices of its commercial partner before the public sector uses the information. It is true that Section 4 does not explicitly require that of federal institution. We think that that requirement exists implicitly. Essentially, imagine federal institutions would be able to contract out, would be able, through contracting with the private sector, to engage in practices that it cannot engage directly. That is unacceptable. We think the law does not allow for that. That said, so is it credible or is it reasonable? There is some credible basis for the RCMP's position. To the extent that there is ambiguity in the law, I would encourage you strongly to close that loophole and to require government institutions, not only the RCMP, but all government institutions, to ensure when they rely on the private sector that what they're buying is lawful.
Thank you. And I guess the follow-up question is, should the powers of your office be strengthened so the rulings on Privacy Act violations are binding and properly enforced, since they seem to have ignored them?
Short answer is yes. We've recommended that many times, yes.
Okay. Just a little bit more data on that use of RCMP. Are you aware of how many convictions they made using evidence collected by Clearview AI?
I am not. We asked how many times they had used it, and it's in the tens of cases, I believe, but the number of convictions, no, I do not know.
Okay, and in your opinion, just knowing how they collected it, could their collection and use of Clearview AI's facial recognition technology risk overturning convictions of any criminal caught or prosecuted using data collected by Clearview?
I think that's speculative. The RCMP says, and I have no reason to doubt, that when they use the technology, there's human review. So that tells me that there's a police officer who then undertakes an investigation and presents evidence through a Crown attorney in the normal rules. That's my assumption, but I don't know that.
The RCMP told this committee last Thursday that Clearview AI was the only modern FRT system they were using, but when asked, could not detail what were other non-modern FRT systems. Through your investigation, are you aware of other FRT systems that the RCMP is using?
We're not aware of other FRT systems that the RCMP is using. There are, of course, many other FRT systems than Clearview's, and they do not all have the same level of accuracy, which is a concern. But as far as the RCMP, we do not know that they are using a system other than Clearview, and they are not currently using Clearview.
Ms. Kissiam, do we know how Ontarians' images are being gathered and stored at this point? So companies using FRT are gathering images. Do we know how they're gathered and stored in Ontario?
Companies? Unfortunately, I don't have insight into companies in Ontario because that's not in our jurisdiction. So unfortunately, I can't answer that question with any certainty.
So I'll stick to public sector then. Do we know how they're being stored?
In general, or using facial recognition technology?
I think in general, including FRT.
I'll give you a couple of examples. Certainly, police services are using images in mugshot databases under the Identification of Criminals Act, pursuant to their powers under that act. There is also obviously much video surveillance that is ongoing in terms of general municipal and other collection of video surveillance, and that too is fairly common and ongoing in terms of collection of video surveillance and therefore images of people.
Thank you very much. Thank you, sir.
And now for 5 minutes, Ms. Hefner.
Thank you very much. Merci beaucoup à tous les témoins.
Thank you to all the witnesses today. I would like to start with Mr. Thérien.
C'est plus facile pour moi.
In English because it's easier for me.
Talked about how all the stakeholders that you consulted with agreed that privacy legislation in Canada needs to be updated. And it makes sense because when it was drafted, we didn't know about facial recognition technology. So I'm wondering what sort of advice you have for legislators to be flexible in the legislation so we don't have to rewrite the legislation every time a new piece of technology comes. How do we make it flexible so when there are more advancements in technology, the legislation still applies?
Question. My starting point would be to say that we do have laws, obviously. We have the Charter, we have the common law, there are some statutes like the RCMP Act that govern the situation. And in the private sector, we have PIPEDA. To your point of flexibility to ensure that a law does not become obsolete, one of the virtues of PIPEDA is that it is principles-based. So it does not seek to regulate particular situations, it deals with principles. But I think for facial recognition, that is where we start to see the limits of the virtues of a principles-based approach. Because if you regulate facial recognition by saying the user ought to be accountable, or principles of that nature, or necessity and proportionality apply, that leaves a lot of discretion to the police to exercise these broad principles in a way that suits their interests. So I'm not saying that there ought not to be principles-based legislation. As a general principle, it makes a lot of sense. But in the case of facial recognition, because of the extremely high risks to privacy and other rights, such as democratic rights of demonstrating or equality rights, we say that there ought to be specific provisions, for instance, in the case of the police, to prohibit uses except in certain circumstances. So a good grounding of principles-based legislation makes sense, But in the case of facial recognition, with an addition of a few specific rules that ensure that the broad principles are not, I'll say, abused or are not interpreted in an overly generous way.
That's helpful. Thank you. I know that the Competition Bureau of Canada is also looking at changes in privacy issues brought on by technology. Can you talk to us about whether you have a relationship with the Competition Bureau, if your office is working in conjunction with that office to tackle some of these issues?
Short answer is yes. We do work with the Competition Bureau. We have discussions with them fairly regularly, but we are limited, both of us, the Bureau and the OPC, are limited by our current laws in that we are not able to share, for instance, in detailed information that we gather in the context of an investigation, because we're both bound by a confidentiality rule which prevents us from sharing with the other regulator the details of what we have heard. So we can have discussions at the level of general principle, we can talk about general trends, but it would be extremely helpful, and we have recommended, both of us in previous months and years, to be able to share what we learned through investigations so that our collaboration can be more effective.
30 seconds left, so I'll just go quickly. We talked a little bit about, well, you said that you were moved by the RCMP saying that that FRT should be targeted, time limited, and subject to verification by trained experts. In what ways is FRT used for good? Like you said, crime or finding missing children. In what ways is this technology used in an acceptable way?
As far as the police is concerned, I think these two examples would be the most important examples. And to crime, I would qualify and say serious crime. I'm not sure that facial recognition should be used for common theft, for instance, given the risks of the use of facial recognition for privacy and other democratic rights. But it can be acceptable, certainly for serious crimes, missing children, other compelling state purposes. For instance, in a border context, to ensure that people of concern can be identified at the border while not impeding the flow of travelers to the country. To me, the necessity to identify people of concern at the border in that context would be a compelling ground.
Thank you, Commissioner. I've another generous round with time there, but I think we have the ability to do that today. So go ahead then, Renee, for your round, 2.5 minutes, and go ahead.
Thank you, Mr. Chair. Mr. Terrien, I'll have to be brief, and if there's any information that you can send us afterwards, that would be great. We talked about Clearview, but companies like Palantir as well are important players in facial recognition and data management. Are these companies capable of self-regulation? Answer, no. Right. So, ethically, they're quite open to exploiting data without very many limits. Answer, I think that's what we've learned in the past years with the use of technology, that we need to put an end to companies self-regulating. And for those in the field of surveillance, they should be targeted specifically. But in general, elected officials need to legislate the use of technology. I think that's the lesson learned in the past years. Could you tell us a bit about Palantir, which is a service provider to the government of Canada? We haven't investigated Palantir, but there are concerns. I wouldn't be able to give comments on the company. Ms. Kossayem, did you work with Palantir? No? Ms. Poitras? No. So for the 4 elements that were mentioned earlier, what would the entity charged with implementation look like? For data protection, we believe that we would have a role to play for the protection of personal data, but for facial recognition, it also factors in different rights being infringed upon, and democratic rights as well. So we're not asking to have a monopoly on the legislation of facial recognition. I think that it would be useful to have different agencies for discrimination, for example, the Human Rights Commission, and something similar in provinces and territories. So we believe that we should have a role to play, but there should be other agencies as well. So a group of agencies. Yes, thank you.
Thank you. And now, Mr. Green, nice to have you back now, and go ahead for 2.5 minutes.
Thank you. And we've heard in the previous answer that the witness today suggested, Mr. Chair, that the private industry is not able to regulate itself. And you'll recall in previous testimony from the RCMP, it was stated that they disagreed with the findings of the Privacy Commissioner in terms of the violations that were present. So I want to ask the Office of the Privacy Commissioner that found that the RCMP's use of Clearview AI contravened the Privacy and the PIPEDA Act. The RCMP testified that they disagreed with the findings in the investigation. So through you, Mr. Chair, why is it that you believe the RCMP violated the Privacy Act and PIPEDA?
So the RCMP is saying that the Privacy Act does not explicitly require it to verify the legality of the practices of its private sector contractors. It is true that the Privacy Act does not explicitly say that. We are of the view that a correct interpretation of that law is that they do have. And if there is any ambiguity in the law, as I've suggested a few minutes ago, I would strongly urge parliamentarians to close that loophole and make it clear.
And so, in other words, they can't do indirectly what they can't do directly. Is that correct?
Exactly.
And yet here we are, a scenario in which we know that police services are using this surreptitiously through many ways of procurement, both through purchases and also, I'm hearing, through trial examples as well. We heard the RCMP in their testimony state they had no idea who signed off on the use of this technology. So through you to the Office of the Information and Privacy Commissioner, are you aware of any other police agencies in Ontario that currently use Clearview?
Clearview has stated to us that they have left the Canadian market, so they're not offering their services at this point to anyone in Canada.
And so through you, and my last question, how would you close the loop with specificity to ensure that these breaches of privacy and information, indeed these civil liberties, aren't breached again in the future, not just by the private sector, but I think most clearly through our law enforcement?
So today I, along with my colleagues, provincial and territorial commissioners, have made a number of recommendations to amend the law. I think it should be done urgently because the risks are very important. So it starts with better laws, and until such time as laws are amended, we have issued guidance on how to use the current law, which we hope will mitigate risk.
Thank you so much. Thank you, Mr. Chair.
Thank you. And now for 5 minutes, Mr. Bazan.
Thank you.
Thank you, Mr. Chair. Our witnesses for their presentations today and participation in this important study, and your announcement that you guys did jointly earlier today definitely couldn't have been timed better, considering the work that we're doing right now. Mr. Therian, you said, just follow up on Mr. Green's questioning, you said the RCMP was unlawfully using Clearview technology. Was there any penalties assigned to the RCMP or to Clearview for that matter?
No, but I would say we should look at this as an institutional issue. We've made recommendations for the RCMP to improve its processes. I would tend to look at it through the eyes of the institution rather than individuals. But no, I'm not aware of any sanctions.
Are you aware of the organization Intel Center Check and the Intel Center database facial recognition technology?
Personally not. Perhaps some of my colleagues at the OPC are. We can provide information if we have any.
Based upon access to information requests that we just got back, it appears that both the RCMP, CSIS, Department of National Defense are making use of this technology. And I think it's something that we need to dive into as well, as potentially in their own documents suggest that they, again, do the use of open source images to identify things like terrorists from the internet and provide that then to law enforcement agencies like RCMP and CSIS.
Information, we'll provide it.
Okay, so if you guys can maybe take that under advisement. When you talk about amending existing legislation, you're talking Privacy Act and PEPIDA. Should it also be extended to include criminal code?
Possibly. I haven't thought about the exact pieces of legislation that need to be amended. As I responded to an earlier question from Ms. Hepner, I think we need to start from principles-based, augment it with a few provisions to ensure that general principles cannot lead to overly generous interpretation. Does that mean, so it means definitely PEPIDA and the Privacy Act, potentially the criminal code. There is a lot of authority in the common law for the use of various forces or technology. So potentially the criminal code could be examined from the perspective of restricting some of these common law powers, but I haven't thought this through seriously.
When you're looking at the use of facial recognition technology and protecting charter rights and privacy rights, should we take the same approach as we do for wiretaps? Like I know that CSE and CSIS do a lot of monitoring of online chatter, trying to focus on things like terrorism, transnational criminal organizations. And again, you can't do indirectly what you're prohibited from doing directly. So whenever they are going to be in violation of the charter, they have to go and get a warrant to ensure that they become charter compliant, or ministerial authorization. Is that, when you talk about, your number one is authorized purposes, is that what you had in mind? Is that there would need to be warrants or ministerial authorization to make the claim that this is something that is required and proportionate to the violations that may happen to that individual's rights?
That warrants may be required in some cases. When we recommend that legislation define allowable and prohibited uses, we have in mind categories of circumstances, serious crime, however parliamentarians may want to define it, that kind of thing. It's not a case-by-case authorization. We come closer in our recommendations when we say that there should be, quote, program-level authorization or advanced notification before use. That's closer to the Quebec legislation, where a police body would come to an independent regulator and say, we want to use FRT in the following use case, not a individual circumstance, but a group of cases, which would be then discussed with the Data Protection Authority and approved at the program level. So that's closer to individual authorization, and it's not inconceivable that in some cases individual warrants would be issued by a judge for an individual case. But that's not our starting point.
Thank you, Mr. Roseanne. And now, Ms. Thompson, thank you for joining us today at Ethics, and welcome, and go ahead for up to 5 minutes.
Thank you, Mr. Speaker, and I'm delighted to be here. My question is for the Privacy Commissioner, Mr. Tarrant. If you, or earlier today, you referenced a moratorium. I believe you indicated that you would support this around the use of facial recognition technology by law enforcement until the regulatory framework around the technology is in place. Would you elaborate on that if indeed you find that you would be in support of such a moratorium?
So our starting point as commissioners, myself and my provincial and territorial colleagues, is that the law should ultimately define allowable and prohibited circumstances for the use of FRT, of facial recognition. That's because we're of the view that there are compelling circumstances where that technology should be usable by police forces. So I would not be in favor of a complete ban of the technology because it does allow use in compelling circumstances. In my reference to the RCMP, I was suggesting that short of legislation that we truly hope will be adopted in the not-too-distant future, if the RCMP were to undertake to use that technology only according to a policy, and the RCMP representative last week identified certain characteristics of that policy, limited, targeted, time-limited, etc., that would be a voluntary, partial moratorium, if I may use that expression. But a complete ban on facial recognition until a new law is adopted, I would not be in favor of that.
Thank you. Would this apply to public spaces, the use of facial recognition in public spaces as well?
Yes, the rules that the recommendations that we're making would apply to public spaces as well.
Thank you. I'd like to, if I could, just move into personal information protection, electronic documents, which is something I've had a lifetime working with. So currently, the technology, it's technology neutral, which allows it to endure over time. Should a technology neutral law apply to facial recognition technology?
We're back to the question I answered a few minutes ago. So principles-based technology neutral legislation for the private sector makes sense as a starting point. The reason we're recommending that for police forces there be specific legislation has to do with the harms of that particular technology of facial recognition. It may well be that certain uses of the technology by private companies raises extremely high risks not only to privacy but to other rights. Clearview is a good example of that. We call that mass surveillance. Mr. Fergus referred to other circumstances. I agree that to denote emotions in order to sell a product or whatever other purpose should not be allowed. I would encourage you to, so we'll provide a few examples of good pieces of legislation. There's a draft legislation in the European Union not yet adopted, which is a good model, obviously to be adapted, and it says, among other things, that facial recognition should not be used to violate human rights, and that applies horizontally, whether to the state or to private companies. That is something I think that Canadian parliamentarians should seriously consider.
You. And one of the threads that I keep coming back to in the conversation this morning is how do you align the realities of the speed of the technology around facial recognition with the need to methodically establish the legislation and the protection around human rights and security and privacy? How do you create that balance?
through principles-based legislation, augmented when need be, given context by more specific legislation. I will add this. I heard you ask certain witnesses at this committee, is it too late? It is never too late. And actually, the fact that certain practices are currently occurring should be no reason for you to prevent yourself from doing the right thing and regulating the technology in a way that respects the rights of Canadians. So we are living, not completely, but in part in a world of self-regulation that has led to certain unacceptable practices. It's not because they are routine or banal, as my colleague Diane Poitras would say, that they should continue to be authorized.
Yes, in keeping with the day here, where we're tacking on about an extra 35 or 40 seconds to each person's round. But go ahead, Monsieur Vimieux, you're next for a 2.5 or so minute round.
Merci, Monsieur le Président.
Thank you, Mr. Chair. Certain studies, well, there's not enough data, but we could find people's sexual preferences, their political affiliations, that kind of discrimination. Is that something that is completely that it's not something that is fathomable? Answer: I don't think that it's not fathomable, and legislation in the EU seeks to ban that because it is a real risk. It's an interesting way for discrimination. We also heard talk about biometric terrorism on databases. Have you come across that in your research in general? Inaudible. So if people would want to falsify data by modifying people's biometric data so that people can get into the country or leave the country for criminal reasons, it comes back to the notion of the necessary protections for facial recognition. There needs to be extremely high measures in place to prevent that kind of risk. Ms. Poitras, earlier you stated that there was no consensus for Clearview. What do you suggest? I think that this is a good question, because in the case of facial recognition, it is hard to have consent because there's an asymmetry between powers, whether it be between the state and individuals or companies, web giants. And it's difficult to have clear consent. This technology is extremely complex. And for an individual to give informed consent is very limited. In order to work on this, we could approve certain recommendations that were made today, and perhaps prohibit cases where even with consent or even with authorization, it wouldn't be appropriate in our democratic society. So it would be important to define in the legislation acceptable uses or not of facial recognition. That would be a step in the right direction.
And now, Mr. Green, go ahead.
Sharon, you'll know that we have spent quite a bit of time trying to begin to understand facial recognition technology, and yet I believe AI offers perhaps an even more expansive way in which public sector and private sector interventions in our day-to-day lives are rapidly shifting our social context. And I think about minority reports. You know, I think about the police's rhetoric around proactive policing and their ability to predict to do predictive policing. So my questions are through you to the Information and Privacy Commissioner of Ontario, who participated in the process that led to a policy on the use of artificial intelligence technologies by the Toronto Police Services Board by providing comments on the draft policy prior to public consultation. Were the recommendations you made to improve the draft policy reflected in the final policy?
Thank you for the question. Certainly, as are all of our consultations with the Toronto Police Service, including the board, the oversight board, they tend to be fairly and actually highly constructive. And I point specifically to our consultation, for instance, on body-worn cameras that resulted in an overarching framework that has since been published. With respect to the artificial intelligence framework that they developed recently and their policy, we were consulted. We made a number of recommendations, not all of which were adopted, and we continue to consult with them in development of the procedures.
So just to be clear on that, which ones of importance would you know today that were not adopted by the TPS?
If I may, Mr. Chair, I would like to ask Vance Lockton. He did the analysis and compared our recommendations with the ultimate policy.
Just unmute yourself, and you're welcome to answer the question.
Thank you. I wouldn't say there's anything that was important that wasn't adopted within the policy that can't be adopted within the procedures. So I think there was a lot of discussion about getting better definitions of risk levels, or better understanding of how some of the oversight was actually going to happen. We kind of have accepted that it's understandable that this high-level policy may not have it, but it's going to be important to see in the procedures that implement that policy.
This to all members that are present today. I'm very interested in finding what their analysis is on artificial intelligence. Maybe they can perhaps provide it in writing to the committee as it relates to the shifts in ideologically motivated violent extremists and the way in which algorithms and social media are impacting the social context. And I reference, the recent disruptions here in the nation's capital and other incidences across the country. Thank you.
Thank you. And now Mr. Bazan for 5 minutes.
Question for all three commissioners. We think there's an understanding that there is certain times that we want to use FRT for police enforcement. How those images are harvested, like scraping social media, is that something that should be banned?
That's the issue that we looked at in Clearview. So if you're within a category or circumstance where the police should be able to use facial recognition and rely on the technology of a private sector partner, we think that the police should ensure that the private sector partner has acted lawfully. And to scrape data from the internet on social media, regardless of the privacy settings of a consumer, for instance, would not be lawful. So that should not, even for serious crime, that should not be possible.
I agree, and I would simply add that mass surveillance is the area that caused us the greatest concern on behalf of all federal, provincial, and territorial commissioners, and that's whether it be done by a private sector, third-party private sector company on behalf of police service or the police service itself. This is an area that we've highlighted in particular as worrisome.
I don't have anything to add to what my two colleagues said, that mass surveillance can be done by law enforcement and by private companies. And whether it be by data means as well.
Of charter rights being violated in the prosecution of individuals in Canada based upon FRT?
such a case, no.
In Ontario?
I'm not aware either. I would just add that to get to that point where there is jurisprudence under the Charter, it will be a long time coming. And this is the concern we had with respect to, and the reason that motivated us to recommend the adoption of a framework, a legislative framework, and in the interim to develop guidelines to help mitigate risks. But for charter jurisprudence, it may take several years before we see the results of your question. Thank you.
In Quebec? No. Okay. So when we look at and I appreciate, first the recommendations, the 4 recommendations. So I'm going forward with legislation, the guidelines that Ontario is proposing. So Commissioner Kosiam, we really do appreciate that input. So, you are talking about in your first on how we use this. And so part of this is going to come under the Privacy Act and PEPIDA. But then when you start talking about common law and statute-specific law and used in criminal cases, and I'd like to know where in the criminal code are we going to make these amendments on how we use FRT so that it is charter compliant.
One of your earlier questions, if in certain circumstances warrants would be required to be issued by a court, then we're probably in the world where these amendments would be made through the criminal code. But the particular instrument, again, I've not given a whole lot of thought about. It's important to look at for the law to be adaptable, therefore principles-based, and to determine allowable and prohibited uses. And if you want to get into mechanics such as warrants, then perhaps the criminal code would be warranted. To add to what my colleague Commissioner Kosiam was saying about the evolution of the law, which takes time. So currently we have a patchwork of laws that governs facial recognition. We have the Charter at the highest end. We have the common law. We have certain statutes, including privacy legislation, but also other laws. It's a complex web of laws. And we have not seen a whole lot of examples of the use of the technology, but through Clearview and the use of Clearview by the RCMP, we have seen that the use of the technology by police forces is sometimes questionable. So you have to act, my point is you have to act fairly quickly, because in the meantime, this patchwork of laws can be used in many, many ways.
Now on to Ms. Sachs for 5 minutes.
Thank you, Mr. Chair, and thank you to all of our witnesses today. This has been really an informative process of learning. Through you, Mr. Chair, I'd like to address, and I'm happy to have actually all 3 witnesses answer. Each of you have talked about the need for strong independent oversight and powers of audit when it comes to these processes of understanding of use of FRT technology, particularly when it comes to law enforcement. But we had brief time with the RCMP and TPS last week, and they talked about risk evaluation in terms of use. And I guess my question is, what will be the mechanisms, or what are the proposed recommendations of who determines that the risk level to justify use? The details are, I'm pleased that there's recommendations today, but the details are pretty thin in how that would be done, because risk could be the risk assessment could be on an immediate need basis. And, it's almost like we'd be assessing after the fact of use if it was justified. So through you, Mr. Chair, perhaps start with Mr. Therrien.
We're back to the complexity of how to craft the law. So say we're within the realm of a serious crime, which according to our recommendations would lead to the police being able to use facial recognition. The law cannot know of all individual cases, so there will have to be, as you say, a risk management assessment made by a police force. What is the conversation with the oversight body, including privacy commissioners? I think it starts with a conversation before the program is put into play, a privacy impact assessment. How are you going to assess risk in a category of circumstances? Then if the police wants to develop a program, we say there should be program level authorization. So the police describes the program, say the protection of very important people in public spaces. That's the program. So there's a discussion between the police and the privacy commissioner on that program. And so that's before the use of the technology. Once the technology is adopted and actually used, oversight should include the authority to investigate complaints and make orders as to the lawfulness of the use of the technology in a given case.
Okay, thank you. And just stepping off on that, on the issue of transparency, when there's a risk assessment done and the level of risk determines that FRT would be used, do you feel that there should be public transparency in this, whether it's in law enforcement or in, and we'll get into commercial settings shortly?
If I may.
Anyone can answer. Yes,
okay.
please.
Thank you for the question. Directly to your latter question, we do believe a certain level of transparency is absolutely critical. We understand that there is not going to be possibility to be transparent with every specific use, but certainly at the programmatic level, including at privacy impact assessments, we believe should be transparent, if not in their entirety, at least a summary of the privacy impact assessments. To your earlier question about oversight, I think there are multiple ways of achieving that oversight short of a comprehensive legislative review, and that includes the role of the boards that play an important oversight, the data protection authority of that jurisdiction, including my office and my colleagues, and also the public. The Ontario Human Rights Commission, for instance, in my jurisdiction, played an important role in consultation with us and others in the development of a body-worn camera program that came into force or that was adopted. So I think there's a multilateral consultation process that needs to take place in terms of determining the spectrum of risks. I just want to make a point that I think we've made several times, is that there is a great spectrum of use cases, ranging from administrative uses of facial recognition that may be on that acceptable spectrum or side of the spectrum that may be adopted.
Okay, thank you, because I know I'm going to be short on time, and I want to make sure I get this in. Madame Poitras, you mentioned, and I apologize that the question is in English, I'm just simply more comfortable. You talked about consent, particularly when it comes to commercial use and so on. So, for example, Cadillac Fairview, other companies that operate public spaces, but they're private property spaces, what kind of mechanisms could we consider in terms of the operating FRT in those spaces in terms of managing it and making sure that the public is informed?
Answer, please.
Thank you, Mr. Chair. So, again, I believe that the mechanisms can depend on the use. There are different forms of facial recognition. There's the one used to identify individuals, but we also use facial recognition for sub-technologies. In commercial uses in malls, for example, where the goal is not to identify the individual, but rather their characteristics, their age, their gender.
way over now, but and I think we can maybe time this nicely, hopefully with expected bells with our final two questioners. First, Monsieur Villemeux.
Thank you, Mr. Chair. 2.5 minutes, correct? 2.5 minutes that I have? Yes. Mr. Terrien, you talked about the work done by the European Commission. Does it include private companies as well, or only government entities? Both? Perfect. So your document can inspire private companies as well? Answer, depending on the context, of course. Are you aware today of entities that are not private companies or government agencies that are perhaps criminal agencies that use facial recognition? Answer, we don't have any intelligence on that. Thank you. Ms. Batra, same question for you. Are you aware of any agencies that are perhaps criminal agencies that use facial recognition? Answer, no, I do not. Mr. Terrien, with the European Commission, do you believe that we could find inspiration in what they're doing? Are they kind of at the forefront of the knowledge on this at this time? Answer, well, their legislation seeks to protect their constitutional acts and human rights, so yes. Is it the best model? I'm not sure if all my colleagues would agree. I think that it is a great model. Ms. Cossain? Apologies, I didn't hear which model you were referring to. The work done by the European Commission, is it a good model? Agree. Answer, yes, I agree. We could use it. Thank you very much, Ms. Potra. I agree, it's a great source for inspiration, and we can make necessary adaptations. Mr. Terrien, do you have any final words, since it's my last round, so you have the floor. Answer. With facial recognition, it is a technology that, when misused, it can infringe upon fundamental rights. I heard questions that had to do with a flexible law, and it is mostly true, but with the consequences, the impacts of facial recognition, I would encourage you to go beyond principles and have more specifics. Thank you.
The final round of questions goes to Mr. Green for 2.5 or so minutes.
Thank you. And going back to this notion of private sector use of AI, third-party use of AI with both law enforcement, even in some cases there's been allegations of political use. So my question through you to the Information Commissioner is has there been within your mandate the ability to explore or study the use of private sector AI for things like nefarious uses of citizen surveillance, phone hacking, and the sort?
Nefarious by?
Well, I'll give you an example. There was a lawsuit about Pegasus, NSO, used to hack into phones of people who were critical of the state of Israel. And we've seen that technology used in different ways. We know that Clearview is one particular thing, but there's certainly Cambridge Analytica and others. So what has what has your office done to provide some kind of understanding about the nefarious use of artificial intelligence as it relates to threats of national security?
I would go back to my general point. Yes, we have investigated the link between Facebook and Cambridge Analytica. We have studied and the use by Cambridge Analytica of data, in some cases, to try to influence political processes. There can be also other nefarious uses. I think it's high time. The lesson is it's high time to stop looking at privacy as a technological issue for the very few, and to look at the use of technology, particularly when it collects personal information, for the link of these technologies with fundamental rights, and to legislate accordingly.
Okay, and I certainly, Mr. Chair, in wrapping up, would look forward to the opportunity to perhaps expand on that and referencing elections that are coming up and allegations that have gone on through various troll farms and different types of social interventions that have happened. And I don't know that we'll have the time to do it this go around. Yeah?
You ask another question.
Okay, well, I guess my question through you to the witness here today is, do we have the ability within existing legislation to adequately account for that private sector influence politically within our social context?
The rules are too vague, I think, to give the necessary level of trust that citizens should have in the collection of information by many parties, public sector, private sector. I think the government recognizes that there's a need to enhance trust. At this point, people use technology because it's convenient, because frankly there's no other way to live in modern times than to use technology. But people do it with not much trust, and it is high time again that elected officials regulate these various areas.
Thank you for that testimony. Thank you, Mr. Chair.
Thank you, and we're just there. You timed that perfectly. Bells are now ringing. So I'm going to adjourn the meeting. We've had, 4 complete rounds, so I think we're ready to adjourn and attend to the votes in the House of Commons. So thank you very much to all 3 of our witnesses. Very informative. Once again, thanks. Meeting adjourned.